The following is a pre-recorded show. Welcome to Winning in Retirement with your host, Brian Akers, certified financial planner professional and founder of Akers Financial Group. Now, helping you win in your retirement, here's Brian Akers.
Welcome to Winning in Retirement. I'm Brian Akers, president and founder of Akers Financial Group. This show, Winning in Retirement, is our radio podcast, and we thank you for listening today. And today we got a special treat for you. What we've done is put together a show called A Proper Legacy First Steps, and the only way to do that show is to bring in an attorney that we use with our clients. Her name is Nelson-Raut. Good morning, Ashley.
Good morning, Brian.
Tell us a little bit about yourself, Ashley.
So my name is Ashley, and I work for Nelson-Raut Law. I'm a co-founder of Nelson-Raut Law with my partner, Kevin Bress. We do estate planning, estate administration, tax work, business succession planning, and estate administration. And I do a little bit of family law as well. And basically, that runs most of my time. But I also am a professor at Stevenson University teaching undergraduate students that are in the legal studies program, ranging from advanced estate administration to estates and trusts to domestic relations to sports law.
All of that at Stevenson in your spare time, right?
In my spare time.
All right. So today our goal is to teach our radio listeners and our podcast listeners, for them to be able to understand a little bit more about estate planning and understanding what a proper legacy would be like. To me, a legacy is what we give to those we care about when something happens to us. And so what we want to do today with Ashley is talk about how she would work with someone from the beginning and really begin to develop why you need an attorney and then what an attorney will do, what happens in that first meeting. But when we start talking about this, let's start with a real basic thing. An estate attorney, break that down on what do they do?
So estate attorneys do a lot of different things. And, historically, going to an estate planning attorney has always been about trying to avoid paying additional taxes upon your death. And now, since the exemptions are so high in the state of Maryland and federally, it's become more about managing family dynamics and making sure that people do not argue when you're either incompetent or the worst happens and you pass away. And so it's really about making a plan that everyone will go along to get along. So that really ranges between meeting with clients and discussing who would make their medical decisions if they're incompetent, who would make their financial decisions if they were incompetent, and ultimately what happens to everything when they pass away, who would be in charge of dealing with the assets and managing the estate. Things as simple as what happens to the belongings in your house. Should the house be sold? Things of that nature. But I would say a very big part of it is managing family dynamics and how that changes when mom or dad pass away or mom and dad are incompetent to manage their own affairs.
Because that's when the kids step up and they all have their own version of their opinion and their own version of what mom and dad want.
Correct. And most times I see it come out with the in-laws having their own opinion, and that kind of also wreaks havoc on the estate administration process. And so that's something that really a lot of my clients talk about, but it's it's probably even more important if you're single or widowed and you don't have any kids to get your estate planning done, because you do not want to be put in a position where you're taken advantage of or anything of that sort.
Estate planning is not just about taking care of your assets and everything you own after you die. It's about taking care of you before you die. And that's the combination of an estate package that you do, where you do wills or trusts, and then you do things called power of attorneys.
Correct. And so a power of attorney is the document that appoints an agent or agents to make financial decisions for you if you were to become incompetent, or for convenience purposes if you were to go into an assisted living or nursing home facility. I always recommend to clients that when you go into those facilities, you really want to hand over your financial inner workings to your agent, because you do not want to have financial information going into those facilities, no matter how safe or how much money you spend on the facility.
Right.
You do not want to have nurses or staff go into your apartment and see your financial statements. Whereas the Advanced Medical Directive, that appoints agents or agent or agents to make medical decisions for you on your behalf if you're incompetent.
Yeah, the hardest part is when you're almost incompetent.
Correct. When you're on the brink of getting fuzzy.
Yeah.
That is the biggest
Usually it's like an
hurdle.
argument, right? It's like, oh, you're fuzzy. No, I'm not. I'm not fuzzy. And then they get in their car and you try to take their keys from them. It's a vicious little cycle there.
It is a very vicious cycle, and usually that takes quite a few meetings with the attorney and the parent and whoever the agent is, whether that's a child or a sibling or something of that nature, to really make the person understand that we're not trying to take away their freedom. We're trying to protect what they've already built for themselves so that we can maintain the assets to pay for the final stages of life.
Yeah, so estate planning is really thinking about, if you pass away tomorrow, what do you want done? Who do you want things to go to? And at what kind of process? Do you want it to go automatically, that where they get all the say, or do you want to control beyond the grave? There's so many different aspects of this, and that's why we have Ashley Raut here from Nelson-Raut Law the whole entire hour. Now, as we're going through our talk today, I got maybe a dumb question, but a new client comes to you. What's their normal reason that they come in? What drives them to meet with you for the very first time?
So that really depends. A lot of times, when the client is going through either their semi-annual or annual checkup or performance of their investments, their financial advisor will say, "Hey, you really should have estate planning documents." Sometimes it's a family event that, someone in their family passed away, or they heard about a neighbor that didn't have their estate planning done properly, and they see the chaos that then ensues, or something of that nature. Very rarely do people come in without a reason to come in, but I would say that it's usually something triggering that they've seen, and they just want to make sure that doesn't happen to their own family.
Yeah, so normal advice, so someone at what age should they start considering wills, power of attorneys? What is that magical age that they should begin thinking about this? So
I see people get their estate planning done typically 3 times in their life. Okay. The first time is when they start having children, okay, because they need to appoint a guardian so that if something happens to them, who's going to take care of the children? We don't want the grandparents to be in court fighting over the children, so on and so forth. The second time is usually when their children are then functional, adults that have already created their life, probably married, out of school, have their career set up, and they're starting to possibly have grandchildren. That's on the horizon. And then the final time is when they're between the ages, I would say, of 70 and 85 years old, and they kind of have a very good picture of what is left at that point. Okay. And where they want to go for their final duration. Yeah. And they need help to determine how to make that all work.
Yeah, I was thinking when clients come in to me and then I try to drive them to an attorney to meet with them, because sometimes clients will go right away as part of the first year in planning. Then there's the clients where every year it's on their list of discussion items, list of things they still haven't done, is get wills, power of attorneys, get everything up to date. Now, what happens is people put it off. Some people don't want to talk about death. I mean, how morbid is this first conversation with you?
To be honest with you, I try to make it as least morbid as possible. Okay. But I really come at it from the fashion of, you really want to make sure that everything goes smoothly, that you're not in a position where you don't want to be, such as like an assisted living facility if you have the means to pay for your own care, or that, the parents don't want their children's relationships to be damaged by something happening to themselves. And so we really just focus on the family dynamics, and that, everybody needs these documents, just like everybody needs to pay taxes every year. Everybody needs an estate plan. And so I try to make it less talking about death and more talking about what type of legacy they want to leave for their children or whoever they desire to give their ultimately their estate to.
When you define legacy, how would you describe legacy to a person?
I would describe it as basically someone's net worth that they've built up over time, that they've worked hard for during their course of their career and then retired. And, sometimes that legacy is a lot and sometimes it's small, but you worked hard for it. So you want to make sure that ultimately the person that is receiving your legacy does not spend it in a way in which you would not approve of. And you also want to make sure that it's protected from things such as that person's creditors or spouse or bankruptcy or things of that nature. So it's very important that you protect your legacy because you worked very hard for it.
Yeah, when I think about legacy, I think about that person and what they do while they're alive, who they give money to, who they care, who they love, who they want to take care of. And the legacy is just a continuation of what you've done during your life. That's why in estate planning, you can add charities, you can give money to different organizations and give money to your family. It's whatever people want to see happen with their assets. And that's a very important part of this idea for the show today, a proper legacy. What's the first steps? It comes down to you think about what you've accumulated during your lifetime, and then how you're going to make sure it gets to the ones that you want to receive the assets, the properties, whatever you might have accumulated throughout your life.
Correct. And, oftentimes clients come in and they're like, I don't really know what I'm supposed to do or what document I need. And what I say to them is, you tell me what you want to have happen, and I will tell you the document that you need to make that happen. Whatever that is, we can make it happen. We just need a path of what you want to do. Yeah,
just tell their story and tell what matters to them and who matters. And a lot of times it's just a whole bunch of little just general conversations as you begin with someone, right?
Correct. And it's just learning what's important to that client so that we can make sure that the important points are included in their documents.
Absolutely. All right. So Ashley Raut is here today on Winning in Retirement. Our show is called A Proper Legacy, First Steps. So throughout the show, we're talking about how you work with an attorney and why you should work with an attorney. And we're Akers Financial Group. We are financial planners. We are not attorneys. That's why we bring in other attorneys from law firms around the country, actually, to help our clients get together their proper legacy. Akers Financial Group is local. We're independent. We don't report to a big company on Wall Street. We report to you. We have offices in Forest Hill, Lutherville, all around the Mid-Atlantic region, and clients all around the country and even a few around the world. It's so easy to begin winning in retirement. Just give us a call and schedule your free meeting with one of our team of advisors. Call 833-WIN-RETIRE. That's 833-WINRETIRE. And we'll give you a call on Monday to schedule your free in-person meeting. Go ahead and go to our website at akersfinancialgroup.com or call us at 833-946-7384 to start planning for your retirement now. What should you bring to your first meeting with an attorney? We'll talk about this in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Well, indeed, welcome back to Winning in Retirement. I'm Brian Akers, president and founder of Akers Financial Group. I'm a certified financial planner practitioner, and at Akers Financial Group, we do full financial planning, financial services. And as part of that financial planning services, we talk about estate planning. And when we do that, we bring in attorneys. And we're doing that today. We're bringing in Ashley Raut from Rowe Law. She's a partner there. We welcome Ashley to the second quarter of our show. Ashley, you ready to go again?
I am ready to go.
All right. I did easy first quarter questions. I'm going to make them a little harder, but not too hard. So the idea here in the second quarter is really to talk about what people should bring to their first meeting with an estate attorney.
Okay. And so what you should bring to your first meeting with an estate attorney, obviously, if you have gotten prior documents done wherever you lived before, you should bring those with you. However, what I typically like to do is I send out 2 documents and I make them very, very simple because I know that the more complex that I make it, it just makes the process harder or easier to put off for clients. So Kevin and I provide an estate planning questionnaire, and that is 1 page, just the front page, where we're just trying to get demographic information from you, spelling of your children's names, spelling of your names, real property, your mailing address, things of that nature. And then there's a few questions on there to kind of get your wheels turning for the different types of things that we'll discuss during the meeting, like, where do you want your assets to go? Who would you want to be in charge of your financial decisions if you're still alive? Who would you want to be in charge of your healthcare decisions if you're still alive. Those types of questions. The second form that we give clients is an asset worksheet, and that is just one page front, just the front of the page. And what we try to do there is kind of a couple different things. Is one, we want to see what your net worth is so that we know what type of, whether you are going to experience estate tax. We also want to see how your assets are titled to see if we need to change your asset titling or beneficiary designations in order to make your estate plan work. And then, from there, I always tell my clients, you don't need to painstakingly get down to the penny of what each asset that you have is worth. It's more of a general idea. It's great if you have a financial advisor and they provide a net worth statement or something of that sort. But a lot of people, they don't have that. So just bringing in that one asset worksheet really helps to kind of navigate the conversation with the attorney.
Yes, because titling and the beneficiaries, how they saved it, how they set it up, all matters in your estate planning on how you line up the beneficiaries, correct? Yes.
And so a lot of people, what the most common misconception for people is this: they believe that their will trumps anything else that they have. And that's not the case. So titling of your assets and beneficiary designations trump your will. Your will only controls individual assets that you have that do not have a beneficiary designation and are not jointly owned. So the only things that pass through your will when you pass away are individually owned assets without a beneficiary designation. And so we could create a very wonderful will that protects all the assets upon your death that pass to your children. But if you leave your children as beneficiaries on your assets, then what happens is that the beneficiary designations trump your will, and then the children have received all of their assets unprotected, and we did a trust for no reason.
Right. Okay. Yeah, so this first meeting is they come in. The meeting lasts, 7-8 hours? What's your normal talk time?
No, so I typically say between an hour to an hour and a half. Now, I will say as you get older, the meeting lasts a little bit longer just because you've acquired more assets or there are more questions kind of having to restructure your net worth in order to cover long-term care and things of that nature. So I would say that on average, my meetings are about an hour to an hour and a half for most people. I try to make it as painless as possible in hopes that they tell their friends and family how easy it was so that they do it as well.
Right.
But also so that they come back and get a change done if it needs to happen. Mm-hmm. A lot of people, they come in, they get their estate planning done, and then they check it off their list and they never think about it again. But that's a problem as well, because you could have somebody named in the document that's no longer with us anymore. So you would need to update that. So, I try to make it as painless as possible. There are no stupid questions. And I really try to just listen to the client and try to figure out what their goals are so that we can meet them together.
I'm trying to come up with a dumb question or a stupid question just because you said there wasn't any. So the person's coming in for the first meeting. Do you charge for that first meeting? How do you work when someone comes in? Should they bring their checkbook with them? That'd be my stupid question.
Some people bring their checkbook, but how it works is this. If you come in and you decide that you just want a consultation, okay, and you don't proceed with getting the documents done, which I will tell you, that does not happen very often for me. Okay. If you do, there's obviously a consultation fee. That's $350 for me. And that gets you about anywhere between an hour to 2 hours of time with me to discuss estate planning. Sometimes people make that first step, but then they just put off actually signing the documents. Right. And so we want to get paid for our time, but we've also given you valuable advice in that first meeting.
Right.
And so if you are getting your documents done, then you pay the bill when you sign your documents. So basically how the process works is we have the consultation. Then within 2 weeks, we send you drafts of your documents, either via email, which most people that does not work out well for because they get aggravated looking at long documents on an email. So we usually mail the documents to them to review. Okay. And then you contact me if you have any changes or questions. We make those changes. We answer those questions. And then you come back into our office and we do the signing where I notarize the powers of attorney. We have all the witnesses there and we get everything sorted out. And then the final thing that we really do in that meeting is we give all of our clients a checklist of things that they need to do, right? So if they have a memorandum in their will about what they want to have for tangibles, they need to do that memorandum when they leave. If they need to get in touch with their financial advisor or the different financial institutions to update beneficiary designations to make the plan work, we actually write out how to update your beneficiary designations for each of your assets. We also talk about where you're going to store your original will, because a lot of people don't realize that you need your original will to open the estate. So when you pass away, if we can't find the original will, that's a problem. So I actually offer clients, if they would like me to file their original wills with the Register of Wills for safekeeping, I take care of that for them. Or if they would like to keep it somewhere else, either at their home or in a safe, something like that, I always put a note in my file as to where it is in hopes that they didn't move it. And when their kids call me and say, hey, where did mom and dad put their will? Did they tell you? I can at least give them a hint as to where they last put it.
So that makes a lot of sense. When I'm thinking about you and being an attorney and they're meeting you in person, and then I think about a lot of people try to do some of this stuff online. What are the dangers of trying to do it themselves online versus an individual meeting with an attorney? So
I can tell you that, yes, you will pay less money if you go on to something like LegalZoom, but you need to keep in mind that you are plugging in your information to a computer that is not a person that can issue spot. And so a very common thing that I see is the LegalZoom platform will not tell you who's subject to inheritance tax in Maryland and won't explain to you that.
Right.
It will not tell you if you have someone that has special needs. It will not tell you that you need a trust, that you can't really leave money to someone with special needs directly because it will ruin their government benefits and make them ineligible. So anything that would be kind of unique to your situation, you don't get a personalized document. You just get a computer that's spitting out a document that thinks it's best for you. Yeah. But what I will caution is that a lot of these documents, you need to go to a specialist. Kind of like if you had a heart problem, you wouldn't go to your general practitioner. You would go to a cardiologist or something of that fashion.
Yeah, that makes perfect sense, because they ask me, and I said, well, we believe individual attorneys, meeting that advisor and having someone you can talk to whenever you need to, because life changes, things change. You need to have someone you can run the questions by, and have an attorney on your side is the right thing, especially with estate planning, especially during the worst times of life, having the estate attorney come in to help handle it. That's very, very important. The hard part for a lot of attorneys, if they didn't write the document, it's hard for them to come in later, like after the fact, after someone passes away, and all of a sudden they got to enact or work with someone else's document. That's got to be a hard thing to do for you guys.
It is, especially since the person's deceased, so we can't change the document to make it say what we would like it to say, right? So if something wasn't planned for properly, there is no going back and changing the document, unfortunately.
Yeah, there's just this is what's drawn up. This is your option. You might have one other option if we do it another way, but it really handcuffs the attorney and also the family when it comes to what might be the very, very best way. The thing that I think is very important is that this first meeting is done, and it's a very important meeting because you get to work right away. As you're having this conversation, you're coming to conclusions on what you should do for your family as if something might happen tomorrow, and that's why you work on these documents, you get them done, and then you're good for a while. It's a very, very important thing that everyone that's listening needs to think about is, do we have documents? Do you have them up to date? If not, go ahead, call, organize yourself so you can have this information and actually get your wills done, and then they're done. Done means done. I like that. Now, the best part about retirement is always about getting your time back. Imagine a retirement is where you get to decide how to use your time. Before retirement, your time is tied up with other commitments, mainly your job. A lot of that goes away in retirement. Your time is now consumed by things that you want to do. It's so easy to begin winning in retirement. Go to our website at AkersFinancialGroup.com, scroll to the Schedule a Meeting section, and let us know you'd like to schedule a free consultation with one of our team of advisors. That's AkersFinancialGroup.com, or you can call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person meeting. Go ahead to our website, AkersFinancialGroup.com, or call us at 833-946-7384 to start planning for your retirement now. Does everyone need a trust? We will ask Ashley when we get back in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, certified financial planner, a practitioner from Akers Financial Group. Here today I have with me Ashley Raut. Ashley Raut is an attorney with Rowe Law Firm, and we welcome her to our show today. We're covering a proper legacy first steps. So far in the show, we've talked about estate planning, some basics. Then we covered what happens in a first meeting. But then I saved the best question for the third quarter. And that question was this. Where's my paper at? I can't find my paper. Where's it at? Oh, there it is. When it comes to basically doing estate planning, people believe that everyone needs a trust. Now, they believe that because they hear that or they get advertised that they need a trust. So the idea that everyone needs a trust, is that going to be something that's a yes or a no or a middle of the road maybe? But the word everyone needs a trust. What's your opinion on that?
That is the $1 million question that I get asked almost every day. And my answer is no, not everyone needs a trust.
Right.
Not everyone needs a standalone trust, okay? And that is a revocable standalone trust that's separate from your will, or it can be an irrevocable trust. And so
can we cover some of the words?
Sure.
I
know
you're
that.
a professor of law, so it's easy to use larger words.
Yes.
You said
let's
trust.
Break it down.
And you said one type called revocable and one called irrevocable.
Yes.
You said it nicer than I did. So can you just define what they are, basically?
Sure. So an irrevocable trust means that you cannot change the trust, okay? Once you put something in that trust, the grantor, being the person who puts something in the trust, can no longer have access to those assets. It sits in the trust for whoever's benefit, and that's done for Medicaid planning so that the government pays for your care instead of using your own assets. Or it can be done to reduce estate tax. A revocable trust, that can be changed, okay? And honestly, what I tell clients, and this is what I say probably every day of the week, is that I, as an estate planner, only see 3 reasons to have a revocable trust, because otherwise you can get the protection that you're seeking through having a testamentary trust, which is a trust established under your will, which we'll get into in a little bit. But the 3 reasons why you would need a revocable standalone trust are: 1, if you have property outside of the state of Maryland, real property outside of the state of Maryland, and you are intending to stay living in Maryland, then you would need a revocable trust to retitle your out-of-state property in your Maryland trust so that you do not have multiple probates over multiple states, which would include hiring multiple attorneys, because not all attorneys are licensed in a whole bunch of states. The second reason would be a blended family. And what I mean by that is it's a second marriage, either for one spouse or both spouses, and they are bringing children in from a previous marriage. And in those cases, that's specialized planning, and we need to do a revocable trust in most cases. And the reason for that is because when one spouse passes, we need to make sure that all of the asset disposition cannot be changed upon the first spouse that passes death, okay? So that we can protect the deceased spouse's children from losing their inheritance if the surviving spouse decides, you know what, I'm going to change my will and give everything to my children and write out my deceased spouse's children. The third reason why you would need a revocable trust, and honestly, it's not a huge reason, but it's to avoid probate, which we can certainly do by having a testamentary trust under your will and updating all the beneficiary designations to point to your testamentary trust under your will.
All right, can I ask you if there's other reasons, like my ones that I talk about sometimes? I don't know if you think they matter.
Okay, go ahead.
Does the ability of a trust by avoiding probate to keep things private, is that a big deal at all in estate planning? It
can be. It really depends on what your asset picture looks like. Okay. So if you're a business owner, right, I can see the reason to do that because you really don't want to have the appraisal of your business to be able to be ordered from the Register of Wills website for 50 cents a page, and then everybody knows what your business is worth.
It's sort of like Elvis Presley. We all know that he died without a will, and it's information's there, his estate. You can see where they put their money, how much money they made, where all the money's going. Right. Every year you just go to Memphis and get information about it.
Right. So it is important, but I can tell you that even if you have a will, you can put the beneficiaries of your assets pointing to the trust under your will, which means that it would avoid probate and you would have that privacy still. Okay. It just skips over the probate process and goes directly into the trust established under your will. So it's really accomplishing the same thing.
So a trust in the will doesn't have to go through probate to get to the trust?
Correct. Okay. If you update the beneficiary designations. Now, I will tell you that there are some things that you just can't really avoid by having a beneficiary designation, such as like an income tax refund. You can't notify the IRS and say, hey, I want any income tax refund to be payable to this trust and this percentage and blah, blah, blah. The IRS will laugh and probably throw it away, right? Yeah. So that in and of itself, that's why you have a will, so it catches anything that is in your individual name without a beneficiary designation and then puts it in the trust. I got one little,
not really a trick question, but imagine, I've been using this word imagine a lot in my conversation. So someone has a trust, and the main reason they had it was to help them in case they were incapacitated. You know, if I even say that word properly, but if they're incapacitated, what happens is in a trust versus just having power of attorneys, is there any difference by having those powers in a trust or in a power of attorney? So, I mean, if you're incapacitated and you have a revocable trust, it does allow the successor trustee to step in your place and manage your finances. Mm-hmm. However, it's important for you to understand that that does not give you any creditor protection. Right. So that trust is still tied to your Social Security number, and you can still be in danger of being sued by the nursing home. But what I will say is that with a power of attorney, that's still important to have, because you can't own your individual retirement account, 401k, 403b, IRAs, things like that. You can't own it as a trust. Right. You own it individually. So if you were to need to take a required minimum distribution or to liquidate some of those funds in your retirement account to pay for your care, and you're incapacitated, then the problem is you're going to need a power of attorney to be able to do those things on your behalf. Absolutely. Now, the power of attorney, I like that a lot and I want everyone, even from younger ages, that's an incredibly important document. And incredibly important to keep it up, to make sure the power of attorneys are who you want to be.
Correct. And so I will say that about younger people, younger adults. I tell all of my clients that when their children turn 18, it is very important for their children to have an advanced medical directive and a power of attorney, because the most common misconception is that because you have your child still on your health insurance, that you are able to just go ahead and get health information or medical information from the different providers. That is not true.
Yeah.
And so having an advanced medical directive, especially when your child's in college, or a financial power of attorney, is very helpful because you can access that information in a pinch by providing a copy of that to whoever's asking for it.
Now, the idea that there's this question, does everyone need a trust? And then there's people that will basically try to push people in different kinds of trusts, irrevocable or revocable, and they're really trying to sell on certain topics. I believe because the state tax law has higher exemptions, there's almost like a new creation of work to do. So these creditor protection trusts, how important are they, and when do they apply to people? When you think about trust and things?
So, there are two different types of creditor protection. If you're looking for creditor protection for yourself, then you're looking at an irrevocable trust.
Okay.
And a lot of people don't want to start doing that because that means that they let go of control of their asset. Once it goes into the trust, somebody else has to be the trustee and manage it. I don't see a lot of people do that until they reach between the ages of 70 to 85. Whereas if you're worried about creditors of your beneficiaries, then the way to go is a trust under your will, which basically it leaves the inheritance in a trust, and the beneficiary is protected from bankruptcy, getting in a car accident and someone sues them above policy levels, they can't get it, divorce, things of that nature. So it's very important, but you have to determine who are you looking for creditor protection for?
Sure. Yeah. It's always important about the outcome, who's in charge, access to money, what do you want to see happening? And that usually will bring us back to the solution, what to do. That's a good thing. I think that planning and doing it, just trying to plan your legacy and what you want to see happening, understanding the destination, then the attorney can guide you on all the things we need along the way. It's almost like going on a road trip. I want to get to this spot, and then we call the attorney gets us to that spot, which is excellent. So the idea with a proper legacy and with trust does have their place. One of the things you mentioned was about property in different states. I just want a quick little question. If we set up a trust while we're working in Maryland, and if we retire somewhere else, do we have to redo the trust, or does it stay the same?
No, you can take the trust anywhere that you want to take it to. As long as a document is signed pursuant to the laws of Maryland, each state will have to respect it.
And that, does it matter on wills or trust if you leave the state?
It's the same for all documents, but the thing that I encourage clients to do is they really should get their will looked over by an estate planner of that state in case there is inheritance tax that I would not be aware of for that state, and there's a way to avoid it. You would want that estate planner who's licensed in that particular state to give you some advice about that.
Yeah, that makes sense a lot, because when people do move out of state and become resident of another state, you got to understand your income tax law, and you need to understand the taxes upon death, the inheritance tax. All very, very important. At Akers Financial Group, when we were talking about planning, everything is designed around you and your goals and your plan. We talk about where you want to retire, where that might be, and then that exact situation applies where you might need an attorney to review the documents that you already have in place and make sure you understand how things will pass on to your heirs in this new state. Whatever happens at Akers Financial Group is going to be about you. Perhaps you've been sold something, regardless of whether you needed it or not. Not at Akers Financial Group. With us, your retirement money, your estate planning follows your financial fingerprint. It's a retirement plan based on your unique fingerprint that determines where your money goes. It's not about us, it's about you. So give us a call at 833-WIN-RETIRE and schedule a free in-person or Zoom meeting with one of our team of advisors. Coming up next, 3 top tips for estate planning from Ashley when we return in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, president and founder of Akers Financial Group, and we welcome you back to our Winning in Retirement radio podcast. Here today, we have Ashley Raut, a lawyer and partner at Nelson-Raut Law, and she's been talking about estate planning. We've been talking about a topic called a proper legacy first steps. We've been going through many things today. We started out with just basically what estate attorneys do, basically planning for the worst thing that could happen as if it might happen tomorrow. Then, of course, what I like to see you guys do is plan your investments as if you might live forever. Then we got into a really important topic, and that is when you meet with an attorney, what happens in that first meeting? And then we asked one of the biggest questions out there is, does everyone need a trust? And the answer was no. That's what Ashley told us. And then we saved the best for last, the fourth quarter, the final close, the winning part of the game, of the radio show. And that is this: 3 top estate planning tips from Ashley. We're going to get that from her, and she might add a few extra because she is feeling very generous with her knowledge. So, Ashley, you really ready for a fourth quarter?
I am ready. Let's go.
All right. So when I think about sports, I love fourth quarters. That's when they win the games, and it's a good time. That's when the crowd's excited. Everybody's just, when they're listening to this radio show driving around, they're more excited because they can't wait to hear the 3 top estate planning tips from Ashley.
Sure.
And a few extra, right?
Yep.
So if you guys missed anything, you can go to our website at akersfinancialgroup.com. Up top, you'll see the radio podcast. You hit that, and what you'll find will be our radio shows recorded and saved right there. Or you can go to your podcasts anywhere that you get a podcast and type in Winning in Retirement, and the show will be right there. All right, so Ashley, 3 top estate planning tips from Ashley. On the first one, what kind of thoughts would you have?
Yeah, so the first one that I would say that is very, very, very important is, well, what happens if you're incompetent and you don't just pass away automatically? You know, a lot of people are very concerned about getting a will, but they don't realize.
We all worry about dying.
Right, but there's usually a transition.
Nothing else is going to happen to us. We're not going to get disabled. We're not going to have a car accident. We're not going to be incompetent. That's not going to happen.
Yeah, no one gets dementia. No one gets dementia here.
Yeah. Yeah.
And what I would say is it's very important to have your power of attorney. If you don't have a power of attorney, the process to get a guardian appointed for you through the court system is costly.
Yeah.
It's very lengthy. You have to file a petition and serve everyone that would inherit from that person if they were to pass away, plus Social Security, the Department of Aging. And it's just, you have to have a hearing, and it's just very, very intrusive. It becomes public record. You have to file an accounting of this person's assets every year.
Yeah.
And so a lot of people need to take that into consideration, that it's such a small cost to get the power of attorney done. And it's such a large cost, both financially and really emotionally, if you have your assets put in public record like that. And so a lot of people really need to take that extra step and get their power of attorney done, because you just don't know what can happen. Even if you don't have a history of dementia or Alzheimer's in your family, you could get in a car accident. You could develop any type of thing. You know, the world is a crazy place, these days. So you really need to have a power of attorney. And I don't see a lot of people putting emphasis on that until it's too late.
Right.
You know, I have a lot of kids that call me and they say, Mom has dementia, but she doesn't have a power of attorney. Yeah. There's nothing I can do about that at that point. You know,
or they call and they say, oh, do you have a copy of their power of attorney? It's like, oh, I've begged them for 10 years to go get it, and they never did. It's great when I can say, yes, I have a copy also. It's wonderful, because normally if the client had an episode over the weekend and we need documents, that's the phone calls we get sometimes. Mm-hmm. That's why, as a planner, we do get copies of everyone's documents. Now, do a husband and wife need a power of attorney for each other?
Yes, you do. You need to have authority from a document to be able to act on your spouse's behalf, and that includes individual retirement accounts. That includes anything that's individually owned. Mm-hmm. And it also includes a deed for a house that you jointly own. You need to make sure that you are able to sign for your spouse if you were to need to take the spouse's name off the deed because they go into an assisted living facility or something of that nature. You're going to need a power of attorney to do those things.
Wow. All right. So hot tip number 1 is, what if you don't die? Power of attorney. Make sure you have one. Make sure you probably redo it every few years. Is that right?
Yes. So our procedure is to send a 5-year letter out to each of our clients 5 years after they have done their estate planning, to kind of let them know that they should look over their documents, and if there's anything that is no longer applicable or the person is no longer available to serve, then they need to come in and get an update.
All right, let's go to your second top estate planning tip from Ashley Raut from Raut Law.
So I think the second tip that people really need to take into consideration is that guardians matter. You need to get your estate planning done, financial power of attorney and will done, so that you can appoint guardians for your minor children or for any children that have special needs.
Right.
If that's not clear and you don't have those documents, it will be very difficult for your minor children or the person with special needs to be able to get someone to manage the funds for them. And it's going to cause additional stress in an already stressful situation. And that can come in the form of the child just doesn't know where they're going, or grandparents are arguing with each other in court about, no, this one takes them, this one takes them. Yeah. So it's very, very important that if you have minor children, you do get your planning done.
Yeah, the guardians, I really think about it with a client has a divorce and a child, and then they do the custody work, but then the idea is in their estate documents, they need to set up the financial guardian for the child, because the child will go back to the other spouse, but then the financial money, you don't really want that to follow the child, right?
Correct. Yeah, you would want somebody that you pick to handle your assets for the child.
Yeah, absolutely. And then you can also control the money for that child beyond age 18.
Yes, yeah, exactly, through putting it in a trust.
And how long can we control money for kids like that?
For their lifetime, and you can actually say what happens to the money after the child passes.
Okay, wow.
Yep.
So a long time if you want to.
Yes, long time.
All right, that's the hot tip number 2. Let's go with the third top estate planning tip from Ashley Raut.
So a lot of people, you need to think about that Maryland has an estate tax exemption up to $5 million. And what that means for people is that everything, all their assets, no matter how it's owned and beneficiary destination, you put them all in a pot. Mm-hmm. And if you're over $5 million, you are subject to Maryland estate tax. So what I can tell clients is if you're married and you're bumping up to that $5 million, or you're just a little bit over that $5 million, it's very, very, very important that when your spouse or, passes, that you get a consultation with an estate planning attorney to file something called a portability election, which plops your predeceased spouse's $5 million onto yours so that you get $10 million exemption. And that will usually get rid of the estate tax problem for people.
Sure, because the estate is everything you own, from retirement to the houses to everything in the bank to everything you own. And once and you're successful and you're growing, or you're building your assets, and all of a sudden the market's good, and all of a sudden things double, real estate gets way up there, all of a sudden you're over $5 million. There's an estate tax. What is that tax in Maryland?
16%.
So 16%. So if you're over by $1 million, that's $160,000 that gets paid within 9 months to Maryland. Is that how that works?
9 months from the decedent's date of death. There is no extension for that.
Wow.
Yep.
And they take credit cards, or?
No, I don't believe that they do. They take a check, and it must be there for the 9 months. So that's very important.
So when talking about estates and when you've been successful, understand that estate planning gets harder, more complex. You need to understand the tax on the transfer of assets to the next generation, and that's where you need to do estate planning and estate documents. So those are your top 3. You got a little extras that we can throw in there?
Sure. So new in Maryland is something that you can file actually with the Register of Wills to qualify your long-term relationship as a qualified domestic partner. And basically what that does is that even though you're not married, if you file this application, then the domestic partner does not get taxed for inheritance tax upon your death like they normally would, because Maryland has a 10% tax on anyone who is not a spouse, children, grandchildren, parents, grandparents, siblings. Right. So before, you would be that domestic partner would be taxed at the 10% level. Now, if you file this filing, then and it's approved, then they don't have to pay the 10% tax. And
that's done while you're alive.
Yes.
And that's something you need to do as part of your estate planning right away.
It's a good idea.
But it's a brand new law in Maryland.
Yes.
And that's just something people need to think about if they're partners and they're living together.
And they don't intend to marry, then yes.
This is a way to avoid the 10% tax.
Correct.
Which will be there through filing basically going through the probate phase.
Correct.
Wow.
Correct.
Now, any other ideas?
The only other thing that I say that I see a lot is that when you get divorced, and I handle quite a few divorces every year, I always provide my clients with a checklist of what to do once they are divorced, once they receive the golden ticket, which is the gold seal judgment of absolute divorce.
Right.
They need to update their beneficiary designations. So it's important for you to understand that even though you're divorced, if you name your ex-spouse as beneficiary on your life insurance policy or your retirement asset and you pass away and you never changed it, that asset is going to your ex-spouse.
Yeah.
So it's very important for you to kind of do some housekeeping after you get divorced.
I've had a few people get hit in my meetings when we log on to their 401k and their first spouse is listed as the beneficiary.
Oh, yes. I'm sure that you see that a lot.
Yeah. So, well, Ashley, we thank you very much for your time today. I know that we're going to invite you to our fall big event we have October 18th. So we look forward to having you there, speaking to our clients and our radio listeners. Today's show was a proper legacy, taking what you have and making sure it gets to the people you love and care about, to the charities you've spent your money and time with, and to your family. These first steps are meeting with an attorney and understanding some of these ideas that you need to implement now. So we thank you very much for listening. Thank you very much, Ashley. I appreciate you coming in to do this. We want you to be winning in your retirement. And go ahead and do that by taking an opportunity to begin planning with us at Akers Financial Group. To schedule your free meeting with one of our team of advisors, you go to our website at akersfinancialgroup.com, scroll to the schedule a meeting section, and let us know you'd like to schedule your free meeting. That's akersfinancialgroup.com, or you can call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person meeting with one of our team of advisors. Start planning for your retirement now. Go to akersfinancialgroup.com or call us at 833-946-7384. Thank you for listening. I'm Brian Akers from Akers Financial Group, and we want you to be winning in retirement.
You've been listening to Winning in Retirement with your host, Brian Akers of Akers Financial Group. Akers Financial Group offers securities through Arcadios Capital, an SIPC and FINRA member firm. Advisory services are provided through Arcadios Wealth. Akers Financial Group and Arcadios do not share any common ownership. Neither Arcadios nor Akers Financial Group provides tax or legal advice. Advice given on winning in retirement is general in nature, and one should seek further advice from their financial advisor, broker, attorney, and or tax accountant before investing. Be sure to read each prospectus carefully to understand all the risks associated with each investment. Examples and scenarios shared are meant to be for illustrative purposes only. Past performance is not indicative of future results.